Have you ever wondered what title insurance is? Have you ever wondered whether title insurance is optional? Have you ever wanted to know if it's a one-time or reoccurring charge? If so, you're in the right place. Stay tuned for the answers to these questions and many more.
Hi, I'm William Dolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn.
Okay, so let's tackle what title insurance is first. This is a policy of insurance paid for only one time that protects your ownership in the property. Now, some people ask, why do I need this? I'm already paying for a title search and a title company or attorney to review everything to make sure it's okay. However, there is a very important but false assumption embedded in this question. The title company or attorney is not reviewing everything that could affect title. Instead, they are performing a standard set scope of diligence designed to pick up most of the easy problems. The rest of the potential items that owners of real estate would generally regard as constituting good and marketable title get picked up or covered by the owner's title insurance policy. Okay, so let's review a non-exhaustive list of items generally covered by a title insurance policy. And they could be anywhere in the chain of title. They're often items that are not going on right now, right? We could be talking about something that happened 5 years ago, 25 years ago, or maybe 75 years ago. But this first category are errors, omissions, and other defects related to public records. So what are we talking about here? We're talking about old mortgages not fully paid or satisfied in the public records, defectively drafted or recorded deeds that create some kind of lack of property ownership clarity, improperly recorded documents, errors in the foreclosure process, bankruptcy issues, lost heirs that might have a right in the property, notice errors in tax sales, defective divorce conveyances, property survey errors, encroachments, boundary disputes, building code violations by a previous owner, conflicting wills, lots of items in that category. The second bucket are unpaid items that can become liens or are automatically liens. So here we're talking about unpaid inheritance taxes, unpaid contractors that result in mechanics liens that are retroactively effective, unpaid real estate taxes, unpaid municipal service liens like water and sewer bills, unpaid condo association fees, unpaid federal, state, and local income tax judgments, unpaid child support judgments, unpaid creditor judgments. The third big bucket are fraud items, fraudulent prior deeds, mortgage fraud where a prior owner lies or presents fraudulent documentation about paying off his or her mortgage, claims related to a forged power of attorney. Again, these are items anywhere in the chain of title, 5 years ago, 25 years ago, 75 years ago. Let me give you a little more perspective. The informal rule for a standard title search for purchase of real estate in Delaware is 60 years. I know from speaking to clients that the common response to this is that there are probably virtually zero problems that arise from over 60 years ago. After all, that's a long time ago. However, I would argue the opposite. In fact, there were so many claims that arose from issues dating back past 60 years that a few years ago in Delaware, there was discussion that real estate attorneys who perform all settlements in Delaware should start performing 100-year title searches. That would be a 67% increase in the length of time searched. Now, I believe 60 years is still the standard purchase search period in Delaware, at least as of the time of the recording of this video. But if there were virtually no issues arising beyond 60 years, there would be no discussion at all about increasing the length of time searched by a whopping 67%. Let's look at an example, but one that is within the 60-year title search period. So let's say a first mortgage company forecloses on a property where another creditor had a subordinate judgment lien. That judgment lien would generally be wiped out by the foreclosure if the judgment creditor was properly noticed. Settlement agents do generally check to see if lien holders were noticed. However, settlement agents do not have any way of knowing whether the judgment holder was properly noticed. Let me give you an example. Let's say that the judgment holder was a person. Did the foreclosing lender verify the judgment lien holder's current address when they noticed him or her? What if the judgment lien holder was deceased and his beneficiaries technically owned the judgment lien at that time? Did the foreclosing lender determine he was deceased? Did the lender properly identify the beneficiaries? Did the foreclosing lender discover the beneficiaries' addresses and properly notice the beneficiaries? What if one of those beneficiaries had also become deceased? Did the foreclosing attorney figure that out? And believe me, it happens. Did it identify the beneficiaries of the beneficiaries, right? Did it discover their addresses and properly serve notice on those beneficiaries? This is what we would call a rabbit hole. There are innumerable rabbit holes in the analysis of title. For a settlement agent to try to resolve all doubt to zero would require them to go down to the very bottom of each and every rabbit hole, which would render title examinations so time-consuming and expensive that real estate transactions would be impractical. As with many risk exposures in our world that are too expensive to directly address, in steps the concept of an insurance policy to cover most of those other risks and keep the process affordable. In this case, this is an owner's title insurance policy. But before we move on, I would like to reiterate that all of these are just examples. Anyone who has ever worked in the title business will tell you the same thing. The number and type of unforeseeable issues that pop up stagger the mind. I was asked a great question the other day by a client. He asked if I, as a real estate attorney, purchase owner's title insurance when I buy real estate. And I think my answer surprised him. I guess he expected that I didn't because he seemed quite surprised when I told him that I would never purchase a piece of real estate without owner's title insurance policy being issued to me. I purchased an owner's title insurance policy when I bought my first property in about 1998. I bought an owner's title insurance policy when I purchased my last property in 2021 and every time in between, which I have to say was a fair number of times. When you think about it, I see all the wacky, unexpected, unforeseeable, and sometimes inexplicable circumstances that arise and cause title problems. So with this in mind, my conviction about owner's title insurance policies should no longer be a surprise to anyone. Lastly, let's discuss whether title insurance is optional or a requirement. There's no law that requires you to purchase an owner's policy for yourself or a lender's policy for the lender. However, a lender can refuse to issue you a loan if you will not purchase the lender's policy. So in that sense, it is sort of required, right? And similarly, a title company or an attorney can refuse your closing if you will not purchase an owner's policy of insurance. Most attorneys also have hardwired into their engagement letters express statements that they can withdraw if you do not follow their advice on a material matter, which I believe would cover purchasing an owner's title insurance policy. Therefore, if you are adamant that you do not want to purchase an owner's title insurance policy, in spite of what you've heard in this video, you need to notify your settlement agent as soon as possible because you may need to find a new title company or attorney, and it may not be that easy to find one that will agree to close your transaction without an owner's title insurance policy. A few quick notes here. There are several types of title insurance policies. Each defines who the insured is differently. In some instances, if the owner transfers the property to a trust or an LLC, their owner's policy will terminate because the grantee of the deed will not be covered under the definition of insured in your title policy. However, coverage would continue if the grantee is included in the definition of insured. To figure this all out, it requires someone to analyze the definition of insured and the details of the proposed transfer. So here we're talking about after you close, right? You will need an attorney to assist you with this analysis or confirmation from the title agent that issued the policy that whatever this new transfer is that you're doing is not going to terminate the policy coverage. Generally, when you purchase real estate, your title policy will be in an amount equal to the purchase price, right? However, that is not because all title insurance underwriters require it to be done that way. There are some different schools of thought here, but the underwriters I use at the time of this recording have indicated to me that properties should be insured for their fair market value. Now, most times the purchase price and the fair market value are one and the same thing. But if you're a real estate investor watching this, you know that's certainly not always the case. Real estate investors make their money by getting properties for less than fair market value. Real estate investors also oftentimes will put a lot of money into the property right after purchasing it to bring it up to the fair market value. If you are an investor, you should also talk to your settlement agent for each purchase separately and discuss your insurance coverage amount options for that particular purchase. If you do not like the answers you get, shop around and see if you can find another settlement agent that is willing or able to be more flexible with the type of business that you do. I know that other real estate attorneys in my area have told investors they are only allowed to insure for the purchase price. However, both of my underwriters have told me they are okay with me insuring for the fair market value and are not limiting me to the purchase price. Now, whether these other attorneys do not know their own underwriters' guidelines, whether their underwriters are more conservative, or whether this is an internal policy of that law firm, who knows? But you should shop around and try to find a settlement agent that is in sync with the types of transactions you are doing. One other note here. Title insurance policies are contracts of indemnity, so there does need to be an actual loss for the underwriter to pay out. So for example, if you insure your $50,000 property purchase for $200,000 and you have an immediate loss before you even do anything, the underwriter is not going to pay you $200,000, right? It would either pay out on the $50,000 purchase price or the fair market value of the property at the time of the purchase, whatever that was. Lastly, title insurance, like all other insurance policies, has exceptions to coverage. They are too numerous and complicated to cover in detail here, but I wanted to at least mention that all title insurance policies will generally accept out easements and similar documents on public record, among other things. Therefore, always get a seller's property condition disclosure. In the event the seller is in a position to know about items like this, that disclosure may be your only or best way to make informed decisions about these items. I hope you have enjoyed this video on title insurance. Please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. Thanks for watching, and I'll see you next time.